Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip, continuing on with the 2020 changes to the GAR contract forms. Today we are going to talk about the changes to the financing contingency exhibits, the conventional loan contingency exhibit, the FHA loan contingency exhibit, and the VA loan contingency exhibit. So please check out the playlist 2020 GAR contract for other videos I have done on all the changes to the 2020 GAR, Georgia Association of Realtor contract forms, and other links below. So, ready to get started? Here we go. So the first one I'm going to talk about are the changes they made to the conventional financing contingency exhibit. So a couple of changes here. One, and this is a really interesting change that I think a lot of listing agents ended up facing and weren't sure how to address. So in the conventional loan contingency exhibit, and that is exhibit F404, under paragraph 3, where it talks about a buyer may apply for a different loan. It talks about that the loan denial letter must come from the lender. If there was one identified as an approved mortgage lender, it must come from that person. And the loan denial letter must be a denial for the terms that were addressed above. So that's always been the same. But here's what they changed. And this is well, let me just read it to you. Paragraph 3, conventional loan contingency exhibit, form F404. Buyer shall not, so it's under the part about where it talks about buyer may apply for a different loan, and it means a different loan than is described up above. Buyer shall not have a right to apply for an FHA, VA, or USDA loan unless the parties agree to amend this agreement to add an FHA, VA, or USDA loan contingency exhibit meeting FHA, VA, or USDA requirements as the case may be. In which event this conventional loan contingency shall no longer be part of this agreement. Nothing herein shall require the seller to agree to this amendment. So what that means is, what was happening is in the competitive market that we were in, the seller's market where there were multiple offers on properties, we had a lot of buyers that were making their offer contingent, and the financing contingency they used was contingent on a conventional loan. But then somewhere along the way, they switched it to an FHA or a VA loan. Well, we know that there are certain costs incurred by a seller on one of these government insured loans. And on a conventional loan, there are different parameters that affect the seller. So, GAR, thank you. We really like this change. They have added this in that if a buyer is going to change to an FHA or VA loan or USDA loan, must have sellers must amend the contract to that effect, and there is nothing that is requiring a seller to agree to that. The other thing they did is last year they added this paragraph about if any lender required repairs were required to a property when a buyer was getting a conventional loan, it had the limit of that repairs, and if the repairs were more than that, how to address those issues. They took that verbiage out of the conventional loan contingency exhibit. They did make that a new special stipulation. So you can, if you are a buyer and for whatever reason you believe that if you're a selling agent working with a buyer getting a conventional loan, and for whatever reason you think the lender is going to mandate repairs on that property, that special stipulation is available to you with that same verbiage, but they did take it out of the conventional loan contingency exhibit. All right, continuing on. Now let's move to the FHA loan contingency exhibit, and this is GAR form F407 FHA, let me see exactly what it's called, FHA loan contingency. And not a lot of changes to this one. Basically what they did is they made the verbiage in this form match the verbiage that they had in the VA loan exhibit and the conventional loan exhibit from last year regarding the repairs. So under paragraph 15, where it talks about repairs required in an FHA commitment. It says any repairs required in the FHA commitment shall be completed and paid for by, fill in the blank, and you negotiate if it's the buyer or the seller, prior to closing, provided that such repairs do not exceed X amount of dollars in total cost. Now that's the same. Here's the paragraph that they added for 2020. In the event anticipated costs exceed the amount listed above, seller shall provide the buyer with an itemized written statement of the total cost of repairs required in the FHA commitment from third-party contractors selected by the seller. Seller or buyer shall have the option to agree to pay the excess amount upon notice to the other party, which shall then constitute an amendment to this agreement. If neither party, neither buyer nor seller, provides such notice to the other within 3 days of the date that the seller provides the buyer with the estimate, or the parties don't agree in writing within that time frame as to how to pay for the excess repairs, then the agreement shall automatically terminate. If the buyer agrees to pay the excess amount, then it shall be paid. Then the same shall be paid by buyer to the seller at closing. So basically, buyer and seller on FHA loan, on this exhibit, they negotiate that if the FHA commitment letter appraisal mandates repairs, you negotiate up front how much those repairs will be. If the actual repairs are more than what was negotiated, now there are instructions as to how to work through that and what happens contractually. Seller is required to go get a third-party estimate, send notice to the buyer, here's what the estimate is, and then buyer or seller agree who's going to pay the amount over what had already been agreed upon in that exhibit, and then within the time frames and notices there are termination rights if they don't come to that agreement. So again, that verbiage had been added in last year, not to the FHA exhibit, but to VA and conventional. This year, they took it out of conventional and added it to the FHA exhibit. Now, continuing on, the next one is the VA loan contingency exhibit. That's worse. So the VA loan contingency exhibit, that one is Form F410, and it is called VA loan contingency exhibit. Now, what they changed in this one was the verbiage about the termite letter. So this paragraph about the termite letter has changed. It changed from January of 2019. It changed by GAR in the mid-year review, June 1st, 2019. And prior to June 1st, it had a lot of verbiage about seller required costs for a buyer getting a VA loan, and it had a whole laundry list of items. In June 1st of 2019, they radically changed that paragraph, and basically, in essence, it says the VA might require certain costs that the VA borrower is prohibited from paying, specifically the termite clearance letter. So now, for 2020, they added more information about the termite clearance letter. Basically, it added verbiage that if there was any damage, previous damage caused by termites, the seller is required to repair that damage. So let me read to you. This is paragraph 14, and it says VA Rules and Regulations Termite Letter. The Veterans Administration has certain rules and regulations limiting the items for which the buyer can be charged relating to the closing of a VA loan. Buyer should consult with the buyer's mortgage lender to determine how the buyer may be affected by these rules and regulations. That's been the same. The rest of what I'm going to read is all new. Notwithstanding any other part, the essence had been there, but they've added some verbiage. So, notwithstanding any other seller contribution, seller shall provide buyer at or before the closing and at seller's cost with an official Georgia wood infestation inspection report meeting the requirements of Georgia law and dated within 90 days prior to closing. So the Georgia wood infestation report must indicate that the property is free from infestation from termites and other wood-destroying organisms. In the event the property is not free from infestation and other wood-destroying organisms, the seller shall immediately cause the property to be treated or retreated as the case may be. such that an official Georgia wood infestation and inspection report meeting the requirements of Georgia law, indicating that the property is free from infestation from termites and wood destroying organisms, can be issued within 90 days prior to the date of closing. Buyer and seller acknowledge that the property may not meet the VA's minimum property requirements if it contains damage from a previous infestation of termites and or other wood destroying organisms. In such event, the seller shall obtain a written estimate from a contractor to repair such damage and provide a copy of the same to the buyer. If the parties are unable to reach written agreement as to the repair of the damage within 3 days from the date that the contractor's estimate is provided by the seller to the buyer, then this agreement shall automatically terminate. So just a lot more specific information about termites regarding a buyer getting a VA insured loan on a property. Basically, buyer can't pay for it. Seller must pay for and provide a clear termite letter. And it can only be 90 days within closing. Can't be older than that. If there's active termites, seller has to get it treated and then get the termite clearance letter. If there is previous damage from a previous termite infestation, the seller, there's new verbiage in there about that either it needs to be fixed or there's termination rights. So again, read through that paragraph really carefully to understand what the parameters are regarding a buyer getting a VA insured loan with respect to the termite clearance letter. So that's about it for the changes of the conventional, of all the financing exhibits. Please read through all of those and stay tuned for more videos on more changes. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.